in order to grow for my daughter? Why should regulations that govern business apply to myself as a mother providing for my daughter? A caring family member will be growing the best medication they can for a loved one. Thank you, but these regulations aren't needed to protect my child. I will. According to this bill, you will find the criminal activity here as compassion, helping a low-income friend by providing our extra cannabis to their baby girl who would otherwise go without. She also shares a similar disease as my child. If this bill passes, I will be subject to whatever madness that DHHS decides to pull, including disrupting our family with armed inspections as per what they tried to get passed in legislation last year. This will no doubt drive up my cost to grow and comply with the law. Example, in addition to the $200 to $400 annual doctor's appointments for certification, $270 yearly caregiver fee, possibly a handbook of requirements I now have to need to design my own grow room, plus other God knows only what things they will require of caregivers in the future. And if I don't register as a caregiver, I am faced with enough civil violation debt to most likely be unable to afford to grow the very medication my child needs to survive, all for trying to save a life with an herb. Ridiculous. Does a restaurant or agricultural business all of a sudden get charged with a Class D fine? We do not need more strict laws, we need them loosened. Referring back to testimonies on public hearing of April 27th, I understand there's problems where people can use the system for criminal activity. York Chief of Police testified as big concern with big grow operations and basically the criminal issues. He is the only person I can credit to testify as a big concern that I absolutely should be addressed. In my opinion, this bill does not solve any of those issues. Bills like this will push people right back to the black market, fearing taking the legal route. I have a dear friend this week desperately seeking options for her child. In a roundabout way, it was a caregiver and patient-to-patient donations and relations that got medicine to that child. That is what matters. This bill would make it illegal for caregivers to donate to other patients other than their 5 designated patients. I beg you, please do not break our system and restrict a caring community with this ridiculous bill that labels them as criminals. Thank you for your testimony. Thank you for considering my testimony. I'll be submitting written in a couple of days, as I just did not have time to really fully grasp this, and there's some more things that I wanted to add.
Thank you very much for your testimony today. Seeing no questions. Thank you very much. Good to see you here. Additional testimony in opposition to this bill.
Hello again, my name is Jody Stebbins, I'm an Augusta resident. I worked for MMCM for a long time. I now work with Maine Matters. I'm here to speak against LD, what is it now, 1329, I think? And this. I think that there's already a lawsuit out against DHHS for overstepping their procedural obligations and implementing things without taking due course. I believe that it's already been proven to be a give an inch, take a mile situation, and to give them carte blanche would be devastating to the wonderful system we've all worked together to create here in Maine. I'm going to skip over a lot of that stuff because you're going to hear a lot about that from other people. But here, the mandate to registration of family member caregivers, that is an unnecessary expense for already low-income situations. Generally, people who are their own family members' caregivers, it's because they can't afford to go to another caregiver. Removing of the sliding scale fee option for veterans is insulting and despicable, and I cannot believe it's even been recommended. I think that's awful. And eliminating the ability for a caregiver to donate a qualifying patient outside of their designated patients. There are so many patients in this state that just cannot afford their medicine. I often cannot afford my medicine. I have abdominal pain so bad I can't get out of bed. I have gone through 3 surgeries in the last year. I can't afford my medicine. Over half of the medicine that I use to manage my pain is by donation. And if this changes, then I don't have my medicine. And that's not okay. And I'm not the only one in that situation. That's pretty much all I wanted to say. Thank you for listening.
Thank you very much for your testimony. Seeing no questions, additional testimony in opposition to this bill.
Good morning, Senator Brakey, members of the HHS committee. I find myself here this morning.
If you could,
Mark Crockett, I'm a caregiver, I'm a patient, and I'm a military vet. So I feel relatively qualified to be here this morning, although I'm not really sure why I'm here this morning, other than the fact that the HHS once again has submitted a bill, overreaching again, without any input from caregivers, and I'm really irritated. I've participated in writing bills and funding a lot of stuff that's taken place, including the lawsuit against DHHS, for the very reason that I'm here this morning. Unlevel playing field. Over 1,700 caregivers have had to work under the regulations and laws that the state has put upon them, while also charging them fees, taxes, sales taxes. I do pay sales taxes. It's an interpretation of the law, if you will, which does need to be cleared up. My concern is, I'm hearing today that there's an unlevel playing field between dispensaries and caregivers. And constantly, we're defending ourselves and trying to be legitimate businesses because we don't have the hundreds of thousands of dollars to monopolize the industry. We're in a position to compete, and that's all we want to be able to do under the regulations that we live with. 30 plants. That's what we're allowed to grow. We're trying to dispense that to as many patients as possible, to give them as many options and opportunities as possible, and yet we're constantly working under rules and regulations that prevent us from being a legitimate business. My effort over the last 5 months was to say, come on, give these over 1,700 caregivers a chance to be legitimate businesses, a playing field that we have to live under because we do not have the opportunity to become a dispensary, although that was in the language at one time that would be reviewed. It has not been. I would say to you this, out of this bill, the most important thing to me is that we're being treated like it's recreational marijuana already. Everybody's jockeying, positioning for it. We haven't discussed that, although it's all in play right now for recreational marijuana. Dispensaries want to become for-profit. And now DHHS saying, we are a 2.5 ounce law. That's what they want, 2.5 ounces. For what? They're going to tell us that we're allowed X amount of patients and X amount of medicine, and now they're going to tell us how much medicine each condition needs? 2.5 ounces for what? PTSD, pain, cancer? Now we're going to be dictated by the government on what type of medicine, how much medicine a cancer patient needs. The gentleman before me made it very clear. It takes a lot more than 2.5 ounces. In a very short time frame, we may have that patient for a month before they've got the medicine they need to accomplish what they need. It's not 2.5 ounces. PTSD and pain need something totally different. We can't dictate from a government position what patients need for medicine. We've already been told we're allowed to grow 30 plants. We're already told that we need to maintain 5 patients to have those 30 plants. And if a patient leaves, we must replace them. We do. And we provide as much medicine for as many patients as we can under that law. I would like you to look at the 2.5 ounce language in this bill and understand we are not recreational marijuana. Different patients need different types and different amounts of medicine. Thank you.
Thank you very much. Seeing no questions, additional testimony in opposition to this bill. And one thing I just will state as a housekeeping note, you may notice there's often a lot of things going on in other committees, and so you might see that particular members of the committee might, as you might see right now, disappear for a little bit. It's because there's other work that's needed to be attended to, but so that's no disrespect to anyone. And if you have written testimony, we all do go through that. So I'm going to be here anyway. So thank you very much for being here.
Senator Blakely, I do take offense. I took a day off to come to this hearing and have the representatives are now missing. Nevertheless, I'm Gary Vitelli, you're my representative. Owner of Growing Compassion, I'm also a member of DHS's Caregiver Forum representing Androscoggin County. That forum was mandated by you 2 years ago. I consider it a privilege and honor to serve in that capacity. I've never missed a meeting of that group. I've suggested monthly meetings instead of quarterly meetings because there's so much work to do in the marijuana field. In the last 6 months, I've come to realize DHHS is not being transparent in its dealings with this state-ordered form. The only listed goal of this form is to foster an increased communication between DHHS and patient caregiver community. It's become apparent to me this has no desire to consider or seriously work with the caregivers at large. Example as such is hiring the Sheriff's Association to inspect caregiver operations. There were 2 meetings of this form while DHS was planning and had that request for proposal in the works. Another meeting on March 4th was 3 days after they inked the $1.6 million contract. Their plan was still never mentioned. Had they shared that request for proposal, I myself or other groups would have bid on that work, provided probably a better service at a lower cost than the $60 an hour we're paying for sheriff's deputies to now come and inspect. I'm here today to ask you to reject 1329 in its entirety as an example of DHS acting without input from all parties. This removes due process as a caregiver, which I'm entitled to, and makes DHS the sole witness, law enforcement, judge, and jury. A few major problems on this one-sided power grab. The Section 9 municipal officer furthering business. I'm not opposed to an inspection, and there's a lot of legislation this year. My grow is my home. If you came to inspect my paperwork, we'd sit at my kitchen table. So I believe it's appropriate that I be given advance notice of someone coming to inspect my property. If you think I'm suspecting illegal activity, then due process. Come with a warrant and come at 2 in the morning. If it's regular business, you've got a complaint, I believe I'm entitled to notice. I'd like to do my dishes and sweep the floor before you come traipsing through my house. Visiting patient in the state 24 hours, needless and unenforceable. And the last big issue, because I'm out of time, I really want to push is the name of a complainant who reports a violation in this act is confidential. I believe I have the right in due process and the right to stand before someone's accused me of doing something wrong. I would like to make it right as a business owner. I'm a caregiver who has if a patient's not happy, I will fully swap out the product or return their money. So if I had a complaint, I'd like to be able to stand and say, let's resolve this. Further, I don't have confidence that with this blanket anonymity of confidentiality, I don't have confidence that DHS itself or side law enforcement won't just make up complaints to come in and investigate, thus taking away my due process. We need more smart regulation. I'd like to be a part of it. That's one of the reasons I volunteered with Ken Albert to be on that committee, which I believe is being unheard. The fact that this law hit my email 2 days ago, and this hearing 2 days ago, is kind of an indication that they're not communicating well with the folks they've invited to be on their forum. Thank you for your time. Any questions?
Thank you very much. Representative Hymanson.
Thanks you for coming. The struggle is, I live in York and I live in kind of a mile away from a growing facility that's had trouble. And so, we're trying to figure out how to help, make that trouble regulated so there's not the trouble. And also pay attention to people who are doing things well. So that's really the struggle. And I think there are a lot of different voices that come into that. I greatly appreciate that you're there. And I wonder if you could share, as I didn't know that there was a caregiver forum even that met 4 times a year. So can you tell me a little bit about that forum, how you were invited, who the other people are, and who makes the agenda?
The forum was mandated by this committee 2 years ago because DHS was taking no input from caregivers, and they pretty much said that caregivers didn't want to be a part of this. I got involved in it because I've known Ken Albert for a number of years, and I told him at a committee meeting here, when I was testifying against the bill from DHS 2 years ago, I told him if there's anything I could do to help further the cause of medical marijuana and make it go smooth, to feel free to call me. That's why I'm on the committee. On the committee is a gentleman who testified here earlier from MCM. They want to have one person for each of the 8 districts in the medical area and the way the state's divided up. They haven't found to fill all the spots. Hillary Lishman used to be on our committee as well as Paul, Corey sits on the same committee. We would have had input into this legislation to stop all this arguing today, but they never told us or asked us our opinion. The same thing with the pesticide controls. We asked for, basically, caregivers are asking for, what's the list of pesticides we can use? what came back to us was a 25-page best practices and pesticide regulation. Best practices can't really be regulations, but according to DHS, this is how it's going to be. When I raised my objections, I was pretty much told this is how it's going to be. I still remember that. I'm still going to do my best to represent fair and honesty and patient concerns as well as reasonable regulation. This law today is more of a power grab than fair, balanced regulation.
I appreciate your voice and thank you for hanging in there.
Well,
I would say it's great to have a constituent here. So
appreciate it.
thank you.
I'd still like to sit with you and talk the big picture sometime.
Absolutely, I'll make myself available. All right. Additional testimony in opposition to this bill.
Thank you very much. The panelists remaining to hear us. I'm opposed to either 1392 or 29. There wasn't a whole lot of time to figure out anything about it. I think that was pretty much a crime that there was no notice at all. I mean, it's a pretty slipshod thing in my opinion. It's like going to court on something that you did and not even having any time to get a witness together. I grew up in a family, I've got 19 siblings, a very Catholic family. I don't know who's going to make, if, as somebody on this panel suggested, 2 members of a family, I don't know who's going to make the decision to choose the other 17 that can't be provided under me. I think that's pretty hokey. I grew up in DHS, and as you all know, DHS throughout the entire country is the most broken part of government there is. Agreed? Okay, I guess not. I'm a caregiver for my wife. We had absolutely nothing to do with marijuana until 2 years ago. It saved my wife's life. Truly saved her life. I feel like if I become a caregiver on a larger scale, I would like to grow high CBD, low THC strains. I'm not in favor of everybody being whacked out all the time. But I'd like to be able to donate to cancer patients or childhood epilepsy patients that just can't afford it. You know, it's a big burden. Insurance companies don't pay for that medicine, and it is medicine. And in this bill, there's also something about sales tax. I have a defibrillator. I have an awful lot of medicines. I don't pay sales tax for them. And patient registration, if I had oxys, if I got a prescription for oxys, I don't got to register with DHS for a prescription for oxys. I mean, that's pretty ridiculous too. If you had a physical problem, or if you had a physical problem and you had a controversial prescription, would it be right for you to have to register with DHS to get your medicine? And again, I think the 2 days notice for this was really broken. And we got the wrong group handling it. And, you know, absolute power corrupts absolutely. And as Mainers, we can't give a broken organization absolute power. It just allows them to do whatever they want, whenever they want, set the rules, and 2 days notice, you be there to complain about it. Some of us work for a living. Sometimes you got to give a week's notice to get the time out of work. You know? That's all I got to say. I mean,
Thank you very much. See no questions. Thank you for your thoughts and testimony. Additional testimony in opposition to this bill.
Chairman Blakey, thank you. Members of the committee, thank you for your public service. My name is Robert Stewart. I'm from Lincoln, and I'm with the Business Alliance for Commerce and Hemp. To me, this LB is much like quibbling over how many angels can dance on the head of a pin. If we think back, in order to ban cannabis hemp from the legal market, the government officials had to swear that this plant, this non-toxic herb, was more deadly than heroin, more deadly than cocaine. It's virtually impossible to exaggerate what the bureaucrats, in describing the dangers of this plant. William Buckley wrote in the National Review, the narcotics police are an enormous, corrupt international bureaucracy with a multi-billion-dollar budgets and multi-million-dollar graft opportunities. They have lied to us for 50 years about the effects of marijuana and now fund a cadre of researchers to provide them with scientific support. Fanatics who distort the legitimate research of others. The anti-marijuana propaganda campaign is a cancerous tissue of lies, depriving the, sick and of needed help and suckering in well-intentioned conservatives and countless frightened parents. That was in 81. In 72, the Virginia Law Review looked at the history of the drug legislation. They described the act as a near-comic example of dereliction of legislative responsibility, a case study in legislative carelessness. The review said that no primary empirical evidence was presented about the effects of the drug. The evidence presented was hearsay and emotional pleas given by the Federal Bureau of Narcotics and a few hysterical state law enforcement agents. This is their quote. Lawmakers assumed that the drug was addictive, caused crime, pauperism, insanity, and death. Anslinger, which irregards, they said the law was tied neither to scientific study nor law enforcement need, and the Virginia Law Review concluded that they had been hoodwinked and hornswaggled. So we have mischaracterized this non-toxic herb and vegetable. Marijuana is a vegetable as a drug. Drugs, by definition, can kill. That's, if you look at the medical encyclopedias, that's the main difference between a drug and an herb. So this is an herb, and like I say, we're arguing about how many angels can dance on the head of a pin. This whole drug war is tainted by fraud. The whole drug war is a gigantic lie. I don't mean to cast further aspersions, but it's designed to enrich a few people and to restrict agricultural commerce and control human liberty and freedom. And we're seeing a touch of that here today. Thank you all for being here.
Thank you very much for your testimony. Seeing no questions, we'll take additional testimony in opposition to this bill. Welcome.
Thank you. Good morning, Senator Brakey, Representative Dean. My name is Logan Perkins. I live in Swanville, and I practice law in Bangor. And I am the lawyer that represents the patients and caregivers who have sued the department for a judicial review of their actions creating the web portal for the patient registration and issuance of the PDF certification. So I'm the one responsible for that you've been hearing about, and I'm happy to answer any questions you have about that. But I also wanted to offer some comments on the bill that's before you this morning, as I do represent a fair number of patients and caregivers around the state in various capacities. But I also want to tell you that the majority of my practice is as a criminal defense attorney. I do that work all the time. I do it every single day, and I practice in both the state court and the federal court. And so I have a pretty good working knowledge of the various drug statutes and the criminal schemes, both state and federal, that criminalize various drug activity. And I want to make a distinction there because I think it's important that the committee know that in my practice as a criminal defense lawyer, I do represent people who are accused of possessing and trafficking and furnishing heroin and oxycodone and cocaine and crack and all sorts of things, but I very rarely see patients or caregivers landing in the criminal justice system, and I think that speaks anecdotally anyway to the integrity and the propriety of the actions of the community in general. So I also wanted to say that the main issue that I have reading the bill before you does have to do with some of the constitutional concerns that were raised earlier and the level of due process available for patients and caregivers who are put in a position of facing civil fines and potentially criminal penalties for violation of this regulatory system. So I'm a lawyer, there's a vast body of regulation that governs me, and a bad lawyer is a lot more dangerous than a little bit of marijuana, but there's no criminal penalties or civil fines that apply to me if I do a bad job. So as a point of reference, I just wanted to start with that and say I'm highly regulated. I have a license through the state of Maine to practice law, but nothing I ever do in my practice will subject me to a civil penalty financially or to a criminal penalty. So I can be sued for malpractice, I can have my license revoked, I can have actions taken against my license, but I'm never going to face criminal charges for being a bad lawyer. And I could do a lot of harm in that capacity. Try not to. But. So with respect to this bill, though, those civil violations and those penalties are enormous. I mean, I just want to draw the body's attention. In fact, I did a little bit of work a few years ago. The committee may remember there was quite a hullabaloo around elver fishing, and I represented a handful of tribal defendants who were accused of elver fishing without a license. They faced $2,000 penalties for that. That's pretty steep. Those $2,000 a pound, you can collect that in about an hour of dedicated fishing. That's a proportional reference point for the committee when looking at what these fines are. And a per day fine is particularly troubling. And I'll just echo, and then I'll stop and take questions, the concerns that were raised about the due process standard that's applicable. The bill actually recites what I think is an erroneous standard of proof that's necessary. For a civil violation, the proof has to be of a clear and convincing standard, and there have to be fundamental pieces of due process in place before someone can be adjudged that civil violation, that civil penalty, including a hearing before a neutral magistrate or a judge, and the right to call witnesses and present witnesses and cross-examine the witnesses against you. And obviously that applies in the criminal context as well. So I'll stop there. I'm out of time, but I'm happy to answer questions.
Thank you very much. Representative Burstein?
Thank you, Senator. Ms. Perkins, can you just go over the lawsuit again? Just give me a little summary of it.
Sure. So, and I will also say that I'm happy to send, I drafted a letter to the committee explaining the situation with the lawsuit, and I'm happy to send by email later today that letter to all members of the committee, as well as a copy of the complaint. It's a public record, as are all the filings in the lawsuit that you guys are free to access, or I'm happy to provide if you would like. But the gist of the lawsuit is 4 patients who were really disturbed when the department, without engaging in any rulemaking process, without engaging in publishing their proposal, without issuing a notice for public hearing or a notice of public comment, without taking, accepting, or responding to any public comment, implemented a vastly different system for issuing patient certifications. This web portal that we've heard so much about that generates this PDF. The department swears up and down it's not transmitting any identifying information, but it is transmitting something. Otherwise, they wouldn't be able to collect the data that they can then present to you in their annual report. So the question is, how in a single PDF are they able to sort out which information is going and which information is staying? And as Shenabelle has pointed out, the question is not if, but when that data will be subject to a breach. So the real issue behind the lawsuit, though, is the lack of procedure, right? The Administrative Procedures Act applies to the Department of Health and Human Services, lo and behold. And they didn't do it in this case at all. They didn't even begin to do it. And that's the real issue, is that without going through the processes laid out in the Administrative Procedures Act, there's no opportunity for the patient community or the caregiver community to engage with the department and say, these are our concerns about the process you're proposing. Let's work together to resolve some of these issues before you implement this thing, which they're now before you seeking post hoc permission to do. I mean, that's a little bit ironic itself, right? They did this thing as an executive action with no administrative process. They got sued over it. It's pending judicial review. And now they're standing before this committee saying, oh, could you please authorize what we've already done? Right? That's problematic from a separation of powers perspective. So that's what the lawsuit fundamentally claims, is that that process wasn't followed and that the court should revoke the action of the agency and remand for proper rulemaking on the issue of how the patient certification should happen. And I'll also say that I've been approached by a group of caregivers who are interested in a similar lawsuit around the idea that the department is now beginning these investigations of caregivers, complaint investigations, and that there are no rules or processes or administrative procedures governing how those processes are going to work. How is a complaint investigation going to work? There was no rulemaking around how complaint investigations were going to work. There was no rulemaking around hiring the Sheriff's Association, which I could not think of a more adversarial entity to hire to conduct those investigations of caregivers. If the department wants to work with caregivers, they probably shouldn't hire the cops to do the monitoring. And I also think that the cops are ill-equipped to do that. They don't know these laws. They're not familiar with the regulatory system.
Thank you.
Sorry.
And just a housekeeping notice for the committee and for anyone else who cares. With the work sessions we're going to be taking up after this public hearing on some of the various bills related to the medical marijuana policy, the bill on the privacy issues around the portal. It's going to be the first bill that we'll do. So there will be plenty of opportunity for more discussion on this particular piece of it. Representative Keane?
Representative Burstein asked the question that covered a lot. So this is a state court action?
It is. It's here in Kennebec County in the Superior
Like
Court.
an ADC with the
It's an ADC.
With the has the department responded to the complaint yet, or have any briefs filed yet?
Well, I outlined in my letter to the committee what I think is the troubling, although I bear some responsibility, procedural posture of the case. And that is that normally under an ADC, the department would have 45 days to generate the record. And in a situation where we're alleging de facto rulemaking with no procedures, the record's going to be pretty scant. But that normally would have 45 days to provide a record. In this case, rather than doing that, they filed a motion to dismiss. There have been exchanges on the motion to dismiss. The motion to dismiss alleged that 2 counts of the complaint, a count for declaratory and a count for injunctive relief, were duplicitous. In other words, that relief was already available under the ADC portion of the complaint, and so those 2 counts could be dismissed. But the purpose of a dismissal where the relief is allegedly duplicative doesn't change the status of the lawsuit, it doesn't reduce the scope of the suit. It was an effort, from my perspective, to delay this issue in terms of its judicial review and getting it stay in the court. You know, I'm not sure what was driving that, but that's the status, is that the case is proceeding for sure on the ADC count because they didn't object to that. They didn't file a motion to dismiss the ADC count.
But the motion to dismiss has been briefed.
It has been briefed. It's scheduled for oral argument in June.
And again, I don't want to prolong this with lawyers, but again, a lot of what you said about the way the department, I understand your argument. It sort of rings true. What's the substantive argument the department has made with respect to why they didn't go through a full rulemaking process? Is there any substantive response in their
No.
in the briefs to the motion to dismiss?
No, none at all. And to me, that's the most troubling, is that I think this is a clear and relatively flagrant violation of the APA. And instead of acknowledging that and beginning to remedy the course of action when the lawsuit was filed and it was brought to the Attorney General's office attention, they've dug in to defend this and filed what I think is a relatively unnecessary motion to dismiss, further delaying the process. So rather than having the government say, oh, shoot, we made a mistake, let's fix it, they're saying, oh, we better dig in our heels and fight. So, and that leads me to one final point that I'll make, which is that if you're going to consider an attorney's fees provision, it needs to be go both ways.
And the only other question I understand, and it's brought up a bunch of times today, the fact that we're hearing this bill, which is very comprehensive on very short notice. The fact of the matter is, at this point in the session, that happens around here a lot. I'm not excusing the process, because we're all living it. It would be helpful for the work session to understand, maybe give us a list of, again, what the really egregious provisions of this bill are from your perspective, from a constitutional perspective. And I know a little bit about that as well. So.
All right, I'm happy to provide that.
Thank you.
Thank you.
Senator Haskell?
My request simply was that you take Anna's lawyer's card so that you can provide that to the committee. That's the easiest way to get it to all of us, is to get it to the clerk. Thank you.
All right, and I will email back a copy of the complaint that I filed, as well as my letter drafted today to the committee this afternoon.
It goes to her, it gets to us.
Seeing no additional questions, thank you very much. Additional testimony in opposition to this bill?
Thank you, committee. My name is Corey Kane. I am from York. I'm actually an out-of-business caregiver and a patient. It seems to me that really the overwhelming tone here today has been the proponent's side of the bill to discuss words like competition, profit, stakeholders. It seems like the opponents are coming at it from much more of just an access for patients angle, which I think is really the overall intention of the program. I'm not here to compete with dispensaries. I'm not here to compete with caregivers. I just want to make sure that if there are patients out there that need this medicine, they're getting it, and they're getting it in the least expensive, highest quality manner possible. The notion that all this oversight is going to create that is somewhat ludicrous. I suffer from cyclical vomiting syndrome as diagnosed from York Hospital, and they've thrown every medication under the sun at me that has been through strict testing and regulation only to make me sicker and sicker and sicker. The one medicine that does work was given to me with no oversight, no regulation, no nothing. And it stopped my symptoms like that. So I just urge you to take into that consideration when looking to resolve this. Thank you.
Thank you very much. Seeing no questions, we'll take additional testimony in opposition.
Good morning, members of the committee. My name is Kendra Corsi. I am a nurse, the president of the Maine American Cannabis Nurses Association. I am a caregiver and a patient myself. And there's a few things that I just want to touch upon that I feel is very important on this bill. First of all, it's been made mention the 2.5 ounce limit per 15 days. And that's reasonable if you're treating somebody for a routine condition such as nausea, vomiting, maybe some pain issues. But I don't think it's reasonable when you're including children with massive seizure disorders or cancer patients. My wife had 4 tumors in her chest 2 years ago, and we were donated a pound of marijuana, which is what was required for the full 90-day treatment. Those tumors are now gone, and my wife's life was saved by this. So if this was put in place, other patients who are facing a similar situation would be greatly impacted. And the other thing I wanted to mention is part of my passion of being a nurse is education of patients and patient support. And I'm a very small caregiver. I only have 2 patient slots. Also, I grow for myself and my wife. People are making mention of huge amounts of money being made by caregivers. That is absolutely incorrect. Most of what we grow is donated to low-income patients because I'm finding the majority of patients in the state cannot afford $250 or $500 a month to get 1 or 2 ounces of marijuana. And again, my passion is helping support these low-income patients and arranging donations, small donations from either patient to patient or caregiver to patient. And I feel like that should not be eradicated. I have had some concerns with the department and communications in the field. I have asked to be part